Добрый вечер всем коллегам в России. Мы здесь собрались как люди, которые занимаются проблемами, связанными с насилием домашним. Я перехожу на английский язык. Меня зовут Ирина. И буду представить нашу коллегу из Вашингтона. Потом перейдем к дискуссии. Я очень рада, что вы здесь. И добро пожаловать. Hello, good morning, Joanne. Good morning to all of our colleagues in Russia. One little bit of technical information. If you're having trouble with the translation, go to the bar at the bottom of your Zoom screen and click on the language you want to listen in and mute the language that is the original. That way you will not hear both the English and the translation. I am very honored to be here today. Many of us have worked on issues connected with domestic violence for years. And I was talking with my friends in Russia, talking with some friends in the United States, and we thought, let's start a series of conversations where we can share our experience with each other. Today is the first of those. And we kind of set it for today, one, because last Thursday was the International Day to Eliminate Violence Against Women. October was the International Month Against Domestic Violence. So we have a reason towards the end of the year to look at our work, over the years. And the first of our conversations today is with a woman whom, if you work on domestic violence issues, if you're a lawyer in the United States who works on domestic violence issues, you are familiar with this woman's work. Her name is Joan Meyer. She has worked in this field, specializing specifically on how to help victims of domestic violence through the legal system. And I would like to hand the microphone over to her for her to introduce her work herself. Joan.
Thank you so much, Irene. It is a true honor for me to be speaking to you and others from Russia. I am frankly in awe of the people who do this work there. It's hard enough to do it here. And my hat is off to everyone who is trying to make things better for abused women everywhere. It's hard to summarize my experience, but I will say I have been working in the field for over 30 years. I've done a wide variety of things, but the things that stand out for me are that I spent the first 10 or 15 years representing women in court and also advocating for improved laws here in the US. And I started teaching about actually almost 30 years ago. And so most of my work was being done with students, law students, but I was also doing some cases on my own and was very networked with people around the country as the domestic violence field was slowly growing and expanding as a field, and more people were doing more different pieces of the work. So I did direct representation with students and without. I then, about 20 years ago, I decided that we needed to launch a new organization that would focus on appellate work, which is when you lose a trial and you want to take the case up to a higher court and ask the higher court to turn that around. And I launched an organization called the Domestic Violence Legal Empowerment and Appeals Project, or DV-LEAP for short. And I fundraised and worked with the board of directors and did the litigation and lots of national and global networking for about 16 years. And then a couple of years ago, I decided to come back to my law school where I had continued to teach, but to come back more fully and to launch a new program from the law school. So I now run and direct the National Family Violence Law Center at GW, George Washington Law School, which is part of George Washington University. And it has been a really good move for me and for the work. And perhaps the most important thing that I've done in the last 6 or so years is I did an empirical study of how family courts are responding to women who report abuse by a partner in the family, whether it's abuse of the woman herself or abuse of the children or both. And what we see here, and I think we're seeing it everywhere around the world, is that courts that are deciding about parenting rights are very protective of men and fathers' rights and are very reluctant to respect or honor abuse allegations by mothers and children. And so I wanted to collect the data on that because we had been complaining about that. We had been seeing it for 20 years in our work at DV Leap and elsewhere. And the courts and the policymakers and the media were not listening. They just did not take it seriously. So I went and with a team of people was able to get federal funding and spent 5 years collecting data and analyzing the data about what the courts were actually doing with numbers. And the numbers were shocking and were consistent with our experiences. So as a result of getting that data, it really has helped increase media interest in the subject and take it seriously. And it has increased lawmakers, policymakers' interest in the subject. So we are working in many states, my center and I and my colleague, Danielle, we are working in several states. Danielle is leading the work to improve state laws on child custody and abuse. It is more of a battle than I thought it should be. There is a lot of resistance to changing state custody laws and practices, even when the goal is to better protect children. So we are learning a lot about why the system is the way it is and why the attitudes are the way they are. And we are continuing to move forward with that. So there's a lot more to say, but that's basically the big picture.
Can I go back to your study? In broad strokes, you don't have to give the exact numbers, but what type of numbers are we looking at in terms of custody issues and the preference to observe the male, the father's rights as a parent as opposed to the mother's? What type of numbers are we looking at?
Well, generally what we found, and please don't quote me, but because I'm going to speak in rough terms here, because I don't have the numbers in front of me, but generally what we found was that when women report abuse of any kind, partner or child abuse, in custody courts, courts believe them less than half the time overall, 41% of the time, if I recall correctly. But in particular, when they report child abuse, courts believe them far, far less. So less than a third or a fifth of the time is child abuse accepted when reported by a woman or a child in custody courts. And this is just the US. Although I will say there's been a series of articles done in a number of other countries, mostly European, and they're all consistent with my research. So that's how often courts respond with acceptance. Then we looked at how often women lose custody of the children in relation to these allegations. And what we found was that generally, women lose custody about a quarter of the time if they are reporting abuse. But if the father who is accused of abuse responds by claiming parental alienation, and I'm not sure, I think you have that in Russia, that concept, but if they respond with a parental alienation claim, that basically doubles the rate at which women lose custody and doubles, more or less doubles the rate at which women are not believed about abuse. And again, child abuse, the impact of a parental alienation cross claim against the mother is even higher when mothers are alleging child abuse. So one statistic that stands out for me always is that we had approximately 50 cases where mothers reported child sexual abuse and fathers responded by accusing her of parental alienation. We only had one court accept the child sexual abuse allegation out of approximately 50. So that to me is emblematic of what is going on in this country, but not only in this country. We have very similar data in Canada. We have very similar data now in France and Australia. There have been a series of studies looking specifically at child sexual abuse and how it is received by custody courts. And pretty much every country is doing the same thing and rejecting it.
So just to recap this, in society, often the mother is considered the primary caregiver to children in many societies around the world. And here I want to be clear to our Russian colleagues, we're not saying this is good, this is bad. We're saying these are numbers. And they're numbers that give us a feeling for what we're battling. It's not just a question of laws. It's a question, as you all know, all of you who make arguments in court, it's a question of how you make your arguments, how you win public opinion, to understand. To have 50 cases of alleged sexual abuse to children, and only that were raised by women, and only one actually coming through that. I work in this field tangentially, only at shelters. I'm not a lawyer, but I work in the field. I am shocked by that number. Okay, and for Janna, who's the translator, we are going to do our best to speak quietly. Not quietly, I'm sorry, loudly, but slowly. Okay. No, don't be apologizing. We need you. You are our most important person other than Joan. Between the two of you, the rest of us can go home.
No.
So just to also make sure that we all understand, what do you mean by the husband claiming parental alienation? What exactly, and not because our Russian colleagues have the same law, but so that we all understand what we're talking about. If you claim I did something and I claim parental alienation, what am I claiming?
You are claiming that my allegation of your abuse is false and is used only to drive you out of the family. Parental alienation is the idea that when a child is afraid or unwilling to be with one parent, that it is probably not because of that parent's behavior, but because of the parent they like influencing them against the other parent. That's the idea of parental alienation, is that one parent is trying to alienate or shove out the other parent from the relationship with the children. And this too is a global concept. And I have heard that it is popping up in Russia, but I don't know how widely. it was invented by a man named Richard Gardner in the US, and he ended up killing himself. And his theory of parental alienation syndrome has been widely rejected, but his followers are bringing the idea of parental alienation all over the world, very actively and aggressively. And it is very effective in denying women's and children's abuse claims. Now, I will add to that by saying that the idea of parental alienation is not limited to abuse cases. But what our data showed, and one of the things we wanted to find out in our study, is that it is most effective in abuse cases that are brought by women. We were able to show empirically that when men report mother's abuse and mothers say that the man is an alienator, a parental alienator, that cross-claim does not have much impact. But when women report men's abuse and the men say the woman is the alienator, it has enormous impact. And that is not a coincidence, because it was invented by Gardner to refute women's child sexual abuse claims in custody. That is specifically how it was invented and how it was used for many years in the beginning. Now it is used more broadly, not only in abuse cases, not only in child sexual abuse cases, but it is most powerful in those cases and most powerful against women, and relatively less powerful when it's claimed against men.
Okay. All right. So let's step back a little. Russia and the US have very different legal systems. And of course, they have different government systems in terms of what organizations you would turn to if you want to report domestic abuse. And what I'd like to do is simply take our Russian colleagues through the process that a woman goes through, or a man, but we'll concentrate here on women, that a woman goes through if she wants to report domestic violence. I guess the first thing that I would think is that she calls the police, or her neighbors call the police, and the police would be one of the first points of contact. What happens then?
So women call the police when they are in fear for their lives or serious, safety. Otherwise, they do not call the police generally. So if they do call the police in the emergency moment, police will come, hopefully, and will speak to both parties, hopefully separately, but not always. And if they believe there is what we call probable cause, which is the legal standard here for making an arrest, if they believe there is probable cause, they will make an arrest of the abuser. But what happens in reality often is that the abuser will claim that she hit me first, or look, she scratched me, which, by the way, scratches are a sign of defensive maneuver when someone is being strangled. That is often all that someone can do, is to try to scratch the other person. So they will point to things like that, and often the woman will be arrested too, or instead. It depends very much on the biases of the particular police officers, and many of them are not particularly sympathetic to women. So if there is an arrest, and if there is an arrest of the abuser, that person is brought to the station and booked, paperwork is done, and they are either held overnight until they can appear in front of a judge and post bond, or they post bond earlier and they are released. So one of many reasons that women don't call the police is that their abusers usually get out immediately and come back. And now they're really mad. So assuming the woman is somehow safe and the abuser has been arrested, then what would happen eventually would be that a prosecutor decides whether to charge the case criminally, and they don't charge every case, every arrest. If they don't, then the charges are dropped, the person is free and nothing happens at all. If they do charge the case, then there's a case in court. It takes some time to go to court. The criminal defendant, the abuser, gets a lawyer. The victim does not get a lawyer. The state is the prosecutor, but they do not represent the victim. They treat the victim as a witness. And many of those cases are unsuccessful because the women do not have the support they need to be effective as witnesses, or other reasons. There may be a very good defense lawyer, and the defense lawyer can attack the woman's credibility by talking about the fact that she went back to him, that she's never reported it before, that she's filing for child custody, and all these things are pointed to as reasons why she's not credible. So a fairly small percentage of cases where women call police actually end up in a criminal conviction. Very small. I think it's probably under 10%, because they drop out all along the way. And if women don't want to participate in the criminal process, most prosecutors will drop the charges altogether. Some very committed prosecutors' offices have a policy called no drop prosecution. And what that means is that we're going to go ahead with the case even if the victim drops out. And we are going to prove the case with other evidence. We're going to use what she said to the police and the 911 call, the emergency call, and other evidence, other people she's reported it to in the past, or medical evidence, or anything else they have and can find to prove that the abuse happened. So that's the criminal process. Now, what tends to happen more often is that women here, there's a very good civil process for women who want to reduce violence, and that is called the Civil Protection Order. And that was invented by lawyers like the ones who, some of whom I think are listening today, who were working with women and who saw that the police were not good enough and wanted a legal remedy that did not depend on the police. So the Civil Protection Order, or CPO, we call it, is a case that a woman can file herself with a lawyer or not. It's a simple petition that states what happened and the date and time. And then it asks for certain remedies like, please tell him to stay away. Please tell him not to hit me anymore. Please award me custody of the children, etc. And there's a wide spectrum of different things that women can ask for in these cases. And these cases go to a judge, a civil judge, and they are heard with both parties are free to testify and present evidence, witnesses, whatever evidence they want to present. And then the judge decides whether the evidence is more likely than not to be true. So it's a lower burden of proof than in the criminal case, where the burden is beyond a reasonable doubt. That's a much harder proof standard. In a civil case, it's just, is it more likely than not that these things are true? And so women often can get civil protection orders, which do not lock him up, but are legal orders that tell him what to do and not do. And then if he violates that, he can be prosecuted criminally by the state prosecutor. So that's another thing women do when they want legal intervention, but maybe not through the police. The third thing is that it comes up in custody. That's a separate matter. That is not women trying to report. That is women trying to protect their kids in a custody context, and then it gets raised for that reason.
Okay, so I'm going to try to see if I can, because people are asking questions and you are answering their questions as we go along.
Oh,
so
good.
I'm going to yeah, no, it's beautiful. But I'm going to try to, since I'm going to try to sum up what you said. So the criminal cases, the cases that would result, perhaps, if they were going to happen, from the police, and the police filing, arresting somebody, the prosecutor examining the evidence collected by the police, deciding whether or not to charge. That's only one legal remedy. And to a large extent, it is out of the woman's hands.
Yeah.
Meaning she is not a defendant or a claimant. She is actually a witness. That is it. She doesn't have her own lawyer. It's the state who is prosecuting the accused abuser. Is that correct?
That is exactly correct.
So then a more common thing would be for women to file a civil case against the man. And in that case, she can have a lawyer and present her arguments. How affordable is getting legal help for those civil cases, and the role of nonprofit organizations versus lawyers that you pay? That question.
That's a great question. One thing I am very proud of in the US is the construction of the CPO, the Civil Protection Order system, and the building of a legal bar. We call it a bar, the profession of lawyers who are licensed. A bar of lawyers who specialize in domestic violence and do these civil cases. And the vast majority of lawyers who specialize in domestic violence cases, which are typically civil protection order cases, are working with legal aid organizations, nonprofits. In the US, we have a national legal service system, which is federally funded and sends money out to each state that has a legal service organization. And in addition, we have funding that comes through the Violence Against Women Act, which was adopted in 1994, which specifically provides funding to support both other nonprofits, non-legal nonprofits, but also legal nonprofits to represent women in court in these cases. So many legal aid organizations are getting grants under what we call VAWA, Violence Against Women Act, VAWA. Many grants come through that, but also there's basic funding for legal services that also comes to these organizations. So I would say the vast majority of people who specialize and really know what they're doing with domestic violence are working in nonprofits. Now, it's not a complete blanketing of the country with these lawyers, but it's not too bad. There are rural country areas with much fewer lawyers and much less access to that kind of help. But most big cities have pretty good legal service organizations, et cetera. What was I going to say? There are also private fee-paid lawyers who earn a living from charging their clients. And some of those know how to do these cases, but many more don't know what they don't know. So they think they know how to do it, but they don't understand the dynamics of courts' responses to these issues. They don't understand the dynamics for battered women of what they're going through. And they don't even understand domestic violence well enough to know how to interview their clients and get all the information. I had one private lawyer contact me some years ago and say, my client keeps talking about domestic violence, but all she's told me about is one time when he pushed her. I can't do much with that. So I said to her, have you used the power and control wheel? I don't know if you have that in Russia, but I think it's international. It's a diagram of all of the different ways that abusers abuse women that don't include violence. So it has violence on the outside of the circle, but it has all these other things that involve coercive control, like using the children, isolating, monitoring, controlling finances. It has all these other ways of controlling and oppressing women on the inside. And I said, use that with her. So later, this lawyer contacted me and said, I had a 3-hour discussion with her with the power and control wheel. Now I understand. So you have private lawyers who don't understand all the dynamics of domestic violence and don't understand that it isn't just violence. It's a very complex web of behaviors and dynamics. And also they don't understand that you will get more information about violence over time. You can't just say, was he violent when? You know, you have to build trust, and you have to know how to respond when you get certain kinds of information so that you build more trust with the client. Anyway, so in my experience, the private lawyers are not as good as the nonprofit lawyers on these issues and in understanding how to be a good advocate for abused women, but they exist. So women who have more money are not even eligible for legal aid, and they have to hire a private lawyer. And it's ironic because I think they get less good representation with more money. And I often tell them that when they do run out of money, you will get better lawyer.
Wow. It's the opposite of what you think.
Yeah.
So do these nonprofit organizations that receive some federal funding, I assume also there are some donors, private citizens who support this work and contribute, do they only work on the civil protection orders, or would they also work on custody battles?
That is a $60 million question, because too few nonprofit domestic violence lawyers do custody. Now, legal services and legal aid, they do custody. It is a standard part of their portfolio. But other nonprofits like domestic violence shelters or domestic violence other programs very rarely do custody. And as a result, the problems I've discussed already in custody have been very slow to rise to the top in the national domestic violence conversation. In a way, it's not really legal aid that's the problem with that, because they are doing those cases. It is the rest of the domestic violence nonprofit network in our country. The big organizations here do not litigate, period. They do a lot of policy work and they do a lot of what we call technical assistance, where they're giving advice and training, etc. But they don't handle cases in court. So they have been very slow to understand what was going on in custody. And they are the ones with the most national influence. But they now are starting to understand and are starting to try to address this in various ways, but they've been slow. So legal aid lawyers do these cases, but there are not enough of them. And the biggest deficit and the biggest need we have here for abused women is custody representation overall.
Okay, I'm going to follow up. One, somebody asked a question about what happens if a civil protection order is violated, and I believe you answered that involves criminal prosecution.
Yeah, so this varies a little bit from state to state. We used to be able to enforce them privately. We used to be able to represent our client in what was called a contempt action, contempt of court, because the violation of the order is considered a contempt of court. And we used to be able to bring those cases for our private clients ourselves. But the Supreme Court has said that because it is a criminal type of action, even though it's contempt, it needs to be handled by the state, not private lawyers. So pretty much most states now, I think, only allow the state prosecutor to bring these enforcement actions. And again, like with any state case, they decide whether they think the case is worthy of their prosecution time. And when they bring the action, they're not as good advocates, in my humble opinion, as the lawyers for the victims are or would have been, which is one of the problems with the Supreme Court ruling on this.
Also, just because, just to be clear, is the civil protection order, is that something that is included in a federal law which affects the entire territory of the US? Did it get introduced state by state, city by city? How did that happen?
Yes, great question. Well, let me make it simple. Civil protection order statutes are adopted by the state. In the same sense, all family law statutes are state by state, and even criminal law statutes are state by state. There are many parallels across states, but there are also some differences. So yes, it's adopted by the state. It was, to me, the biggest success we've ever had in domestic violence in this country was the invention of the civil protection order concept. And it was invented by advocates here in DC who were troubled by police response and who said, we need a civil alternative that doesn't depend on the police. And it was a very clever model. And it was adopted here in 1970 and then slowly was picked up by every other state. So by the end of the 1980s, every state had their own civil protection order statute. And again, they're similar in many ways, but they may define domestic violence differently. They may define the remedies that you can ask for differently. They may define what relationships are covered differently. Some states don't have protection orders for same-sex relationships. Other states have litigated that issue and established that you absolutely can have a civil protection order in a same-sex relationship. So these things develop as a matter of state law.
If they develop as a matter of state law, if there is a civil protection order given down, and then the woman moves to a different state, and
Yeah.
the abuser follows her to
Yeah.
that other state, and then he violates the order, does the new state prosecute? The old state prosecute? How does that happen?
That is historically was a big problem for us, and it is still not smooth. About 10 or 15 years ago, one of the national domestic violence groups pushed very hard for a new provision in the Violence Against Women Act called the Full Faith and Credit Act. Full faith and credit is referring to a constitutional provision that we already have in our Constitution. And what it means is that every state has to credit the legal rulings of other states. So you can't ignore it just because it came from another state. So this provision was adopted to say we need to train police and prosecutors and judges to do this, to respect the civil protection orders of other states, because they kind of weren't. And so now there is better reciprocal enforcement of different states' orders, but sometimes it's still a problem. For instance, in theory, the police should arrest for a violation in the second state, even though the order is from the first state. But police don't always do it right because they aren't thinking about full faith and credit. They're thinking, this is not an order from my state. That's all they're thinking. So training is a big part of this. And again, having lawyers for victims who can speak to the police or bring the case to court another way to get it enforced is very important. So we have improved that problem, but I don't think we've fully solved it.
And who is responsible for that training of the police in another state?
I'm going to guess a little bit. I think that these national organizations, I'm thinking of the Battered Women's Justice Project, which really pushed this issue and led on this issue nationally. I think they have done many trainings on this around the country. Sometimes they do a national training and people come from different states on these issues. I don't know how much the local domestic violence trainers are training on that issue. I think it tends to be the national groups because they're looking at the problems across states, whereas the local groups are not necessarily as much looking at that. So I can't tell you how much that's still happening. And, you know, the pandemic has, one silver lining has been that we are all learning to do online, everything online. And I'm hoping that there's more of this going on online now, but I don't know for sure how much of this particular training on interstate problems is happening. We do have one organization that I should mention called the Legal Resource Center on Violence Against Women. It's based in Maryland, but it's a national entity that focuses specifically on interstate problems in cases involving custody and abuse. So the question you asked about civil protection orders, we have the same issue with custody when women flee from one state to another and there's a custody case going on. And there are specific statutory rules for that as well. And that organization focuses solely on that issue of what happens across states with custody when women flee. But with the civil protection order practice, I mean, and that organization can address that too. And they do trainings on both, I think, as well, I should say. Yeah.
So I'm going to ask you one question also about court proceedings, and then we're going to back up a little. But I want to make sure that I understand this. So because family laws are often different state by state, as are civil laws, does this mean that the definition, the legal definition of domestic violence is different from state to state. There is not a national consensus on what domestic violence is.
Nope. And it's even more complicated than you just said. Most states do not define domestic violence for universal all purposes. They may have a civil protection order statute, and it says, if these things happen to you, you can get a civil protection order. But then they may have a custody statute, and it might say, if those things happen to you, that will help you in custody. But they may not be the same things. And then they may have a third statute, a criminal statute that just says violent assault is a crime, but doesn't talk about domestic violence. So domestic violence is often not defined in the law as domestic violence. It's just, here's what we're going to call domestic violence for this purpose, and here's what we're going to call it for that purpose. And we don't need a definition of domestic violence per se. We just need the definitions for each purpose. And then at the federal level, you kind of have the same problem. You have the Violence Against Women Act, which does define domestic violence, but it's for purposes of that statute. So it defines it for purposes of its federal funding, or for particular legal things like full faith and credit, or various other laws like firearm restriction laws and so forth. It has its definition, that's one federal definition for those purposes, but it may have other federal definitions for other purposes. And so you always have to look at your statute that you are working under or working with and see what definition it's using. There's no universal definition of domestic violence. Now, that's the legal picture. But when you leave legal and you go into things like counseling or shelters or other kinds of advocacy, in that world, people have the broadest definition because they know what I was saying about power and control and coercive control and the power and control wheel. They know all the levels and dynamics, the psychological dynamics of domestic violence. And they are frustrated that the law doesn't address all of the psychological dynamics. So we have, whenever I write about domestic violence, I have to talk about which definition I'm using and why.
So given that non-lawyers like me would have one more broad definition of domestic violence that would include psychological, include emotional, include physical. If I'm going to a lawyer for assistance, you'll end up using articles from very diverse laws that wouldn't necessarily be connected with domestic issues in order to talk about psychological violence?
Well, no, a lawyer who helps a battered woman is going to use the civil protection order law or advocate for them on the criminal side or custody. So that's basically the three sets of laws that we use with battered women. But at the same time, a lawyer for battered women is going to know that there are a lot of dynamics of domestic violence that the law does not address. Specifically, psychological abuse is a major issue of discussion here among reformers and people who are trying to strengthen laws and so forth. How much should we cover coercive control? How much should we cover in the new law psychological abuse? What are the benefits and risks of doing that? And right now, most laws don't cover coercive control. This is a new thing that state laws are starting to address, thanks to the UK and Scotland and Ireland and New Zealand and a number of other countries that have criminalized coercive control. The US is starting to talk about it, but not about criminalizing, because of the racial justice movement, which is so negative about the criminal justice system. We are not looking to add new crimes right now, if we are progressive advocates, but some of us disagree on that. But that's generally the view of the domestic violence field. But on the civil side, coercive control is starting to be looked at and adopted. So a couple of states have adopted it for civil protection orders, and a couple of states have adopted it for custody, which is really good, because coercive control is not the only form of psychological abuse, but it is a very good and pretty broad construct that we can use to cover most of what we see as abuse. So, and it's helping educate judges that abuse is not just physical, and these non-physical forms of oppression can be even worse than the physical, and they are relevant to how someone is as a parent and not just their relationship issues. So we are starting to contend with and pay attention to that part of psychological abuse, but it's slow, and it's only a couple states so far.
In Russia, there is an understanding of a conclusion by an expert that can be introduced into court. I don't know the proper wording in English. Maybe it's the friend of court, maybe it's something else, but it's when you have experts officially submit their opinion for consideration in a court case. Do we have that being used in domestic violence cases here in the US? And if so, are they being used in the criminal, the civil, or the custody proceedings?
So I have a slightly complicated answer to that question. The answer is yes, we can have expert witnesses in all kinds of cases. And there are two types. One type is when the lawyer hires the expert as a witness for their client. And they present them as a witness for their client, but they are an expert witness. And there are rules about that. And you have to prove that they really are expert and all of that. The other type of expert that exists is when the court wants to appoint its own expert who is considered a neutral, not on either side. And that is used almost solely in custody, because custody judges feel like they don't know how to judge who's the best parent or who the child should be with. And they want a psychological expert to tell them. So they appoint what's called a custody evaluator, and there are different names in different states. Custody evaluator is supposed to investigate, interview both parties, interview the children, interview other witnesses, investigate everything about the family, and then make a recommendation to the judge. And unfortunately, those experts tend to be very, very bad on domestic violence and child abuse. And we have a huge movement in this country now called the protective parent movement, who are fighting what's going wrong in custody. And they're especially focused on these custody evaluators, because so often, not everyone, but many of these evaluators don't understand domestic violence, and they call it parental alienation. So when the mother reports the abuse, she is now a bad actor. She is an alienator, and dad is suddenly has a leg up, has an advantage in the custody case. And the evaluator basically hands custody to the dad. when mothers report abuse, very, very often. And even though they are just supposed to be an opinion, most judges follow them because, first of all, they think they know more, even though in reality, these evaluators don't know more about abuse. Secondly, many judges want to protect fathers' rights. And so when the evaluator says this father is being falsely accused, they are happy to protect the father and to reject the abuse allegations. So children are suffering terribly. And we have a database, a growing database of children who have been murdered because of these opinions and these decisions to protect fathers' rights at the expense of the children's safety.
So is an answer in that particular, or an answer, I want to emphasize, I am not saying the answer, but one thing to rectify that situation, would it be training of those evaluators, or would it be adopting a new regulation, or both?
You are on our cutting edge, Irene, because this is being debated everywhere now and nationally. I am part of one group in New York that is discussing that very question. But I will say that generally around the country, the focus is on training, if at all. It has been very difficult to take on what I will call the culture of family courts, which is, there are so many levels that are not, sorry about that, that are not purely legal. Ginger, no.
So many levels of family court.
They're not purely legal. And the evaluator is a good example of that, because you could constrain it legally, but that's never been done. And there's debate about whether the legislature can tell the court what it can and cannot do with regard to experts. So those are all untested questions. In terms of training, there's only a handful of states, four or five, that even require specialized training on abuse for evaluators. And Colorado just adopted a new law requiring 6 hours on domestic violence and 6 hours on child abuse. But there was no training in existence. So my Family Violence Law Center jumped into the breach, and we have put together 12 hours of training. I think I mentioned earlier that we are doing in live webinars for Colorado evaluators. And there's a few other people offering trainings, not just us, for sure. And the evaluators are having to do this for the first time in their experience. They're having to sit through 12 hours on adult and child abuse. It's not enough. I don't expect training, even 12 hours, to change people's attitudes. If they have attitudes of that women lie, and that fathers are falsely accused, and that sexual abuse is rare, and all these things that are wrong and not true. But if they have those beliefs, I'm not sure our training is going to change it, because those beliefs are connected to attitudes about men and women and what is right, and authority in the family and men's rights and all of those things. And information doesn't necessarily touch and change attitudes and belief systems and value systems. So we're trying it. We're going to try training and see how much difference it makes. But I am not holding my breath that that's going to be a complete fix. So I think the question of, should we eliminate these court experts because they're not expert in ways they absolutely should be, and they're biased in ways that we cannot fix through training. That is an ongoing discussion that is only starting to happen.
So crazy.
Yeah.
Domestic violence has been going on for millennium,
Yep.
and we're still only at this stage.
Well, and that is because it's not a question of knowledge. It's a question of bias and value systems, and we haven't changed those yet.
So a connected question here that has a lot to do with bias and culture is the US is well known around the world, certainly in Russia, as a place where people can have guns. And in the home. And we all know there are statistics that often those guns, by mistake, are used against your family members because you think it's an intruder, perhaps. But there must be cases where you have a domestic violence victim who goes to protect herself with a gun, or you have an abuser who uses a gun as a final solution. So this is a two-sided question. On the one hand, what is the practice in the US? Are there examples of victims of domestic violence defending themselves with guns? And is it respected as self-defense? And abusers who would use a gun to actually escalate the violence?
I'll start with the second part first. Guns in the hands of abusers is a huge problem. And we, for what it is worth, we do have pretty good federal laws on that. And the federal laws, the Violence Against, well, actually, it's not the Violence Against Women Act. It's a separate crime law that addresses handguns, specifically says that if you've been convicted or there's been a civil protection order against you for domestic violence, and it defines domestic violence in its own way, to some extent, it actually says under the state laws that define domestic violence. So that's, anyway, but if you've been convicted or had a protection order against you, you may not own a handgun. And when guns are sold, they're supposed to be checking all these things. And when guns are used and there's an arrest, they're supposed to remove the guns from people who violate that standard. Now, that is imperfect, and there are nuances to what constitutes the misdemeanor crime of domestic violence, or what constitutes, what met the standard under the federal law. And those cases have been litigated in the Supreme Court, 2 or 3 of them. I've been involved in friend of the court briefs in those cases. And there's some technical complicated issues around that. But basically, we do have federal laws that say you can't possess a gun if you've been convicted of these things or had a protection order against these things. So that's sensible. Now, what happens on the ground is that abusers are still killing many, many victims. And in fact, what we see is that with guns, and what we also see is that mass shootings that are so rampant in the United States, many of these mass shooters are domestic violence abusers, and often they kill their victim first, and then they go out and shoot others, or they're prevented from hurting their victim, so then they go out and shoot others. The guy who ran his SUV through the crowd in Wisconsin last month had a domestic violence history. He tried to run his girlfriend over, and then he went and did this to a crowd. It is, when you say domestic violence has been around for centuries and we still don't get it, it's violence. It's violence against women. It's not just limited to women. It's men who are violent, and they bring it outside as well. And the culture has yet to understand that. So anyway, so the story with guns is, yes, it's terrible, terrible problem for victims. It's not only used to shoot them, it's used to intimidate them. So, a man will put the gun on the table. A man will conspicuously start cleaning the gun in front of the victim. I had a client who fled to a shelter with her children after he took out the gun, didn't say much, was clearly angry at her, started cleaning it. That's all she needed. She fled. So guns are a huge, huge problem, although we have these laws. In terms of self-defense, the minute you asked that, a horrible case came to my mind. I don't have a broad picture, but I have this one horrible case in my mind about women using it in self-defense. There was a woman, I forget what state, her partner was abusing her. He went out to the garage and she had hoped he was leaving, but he didn't leave, and he came back in and she could not really get away without his stopping her or something. So she shot a gun in the air to make him go away. The prosecutor arrested her, convicted her, and had her in jail for years, I believe it was. There was a whole free her movement that started locally and spread nationally. We all signed on, free this person. And she was in jail for years before she got let out for having shot a warning shot against her abuser. So I know that is one prosecutor who clearly does not believe women have the right to self-defense, ever, 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 even when she didn't hurt him. I get that, that's one prosecutor, but I think that is probably not limited to one prosecutor, that attitude. And we certainly see in cases not involving guns that when women, for instance, when they scratch their husband who's strangling them, they often get arrested for the scratches. So no, there is no understanding of self-defense for women in this country. And it's a travesty, in my opinion.
So you previously, for 30 years or for 20 years, worked with an organization that you founded that dealt with the appeals process on domestic violence cases. In the case of this woman who did not kill anybody, did not even wound anybody, but shot her gun in the air to basically tell her abuser, hands off, I want to leave. Did she file an appeal after she was put in jail? I mean, would the appeals process is that how she finally got freed, or was it that her sentence was over?
I wish I knew the answer to that, and I don't. If she had filed an appeal, it would have had to be her defense lawyer filing that. And some good, aggressive defense lawyers would do that, but many defense lawyers are not good and aggressive. And many defense lawyers, just like prosecutors and judges and others, don't really understand that women have a right to self-defense. So the biases that we see that are unstated, that are not in the law, but that many people harbor about the roles of men and women, can distort legal advocacy. So, I don't know. I'm hoping that she had a good defense lawyer, and I'm hoping that the movement that sprang up around her, fueled a defense lawyer's advocacy and supported them. But I'm afraid I don't know those details. And the kind of work, one of the challenges for my organization, DV Leap, which, by the way, I was there for 16 years to be precise, but not 20 or 30. And they are still going. They're still going strong. If we had wanted to get involved, we could have reached out. DV Leap is always overwhelmed with more cases than it can handle. It's much too small. It needs a lot more funding to hire more lawyers, and it's been difficult. But we would have reached out, and then but we would have only been able to do a friend of the court brief because the party is the defendant in a criminal case, and we are not able to represent a defendant in a criminal case. And the prosecutor is the other side, and they're the state. So anyway, so it's a little tricky in those cases, but not, we could, in theory, we could have supported that appeal. We did not in that case.
Okay, so when we keep coming back to the issue of bias that victims are encountering at all levels, we talked a little bit about training that has just started for evaluators on domestic violence, on coercion, on child abuse, custody battles, etc. Are there programs, ongoing programs at the federal or perhaps the state or perhaps the municipal, the city level that conduct trainings for judges, that conduct trainings for police on these issues?
So again, a somewhat complicated answer. There are national nonprofits that train judges. One of them is called the National Council of Juvenile and Family Court Judges. And they have an entity called the Judicial Training Institute, which partners with a nonprofit. And they have been training judges, but not by mandate, all by choice. They've been training judges, for many, many years on domestic violence. They too were slow to the custody problem. I don't know how much custody training they even still do, but not as much as general domestic violence training that relates to criminal and civil protection order and just understandings of domestic violence generally. So they do it, but it's judges' discretion and whether they can get the funding from their court to go fly to San Francisco or wherever that training has historically been held. There is no federal mandate for judicial training. There is federal funding for what that entity that I just described does, and they have to apply for grants for that. And then there are people like me who get asked by different courts, come train our judges or come train our family judges or whatever. And I will do an hour here or there, or 3 hours here or there for one court, one bunch of judges. Occasionally I've done a couple days. And those trainings tend to be mandatory because the court is organizing them and requiring judges to attend them. I have found that trainings for judges, especially in the custody area, are really problematic because the judges, kind of like the evaluators and everyone else, have their views and don't like being told that their views are wrong. So it's very tricky to train judges in a way that they will accept. And many judges are kind of wedded to their views, perhaps their biases about men and women in abuse. Some judges, we know historically that some judges beat their wives. I've written about that. We know that some judges, just like some percentage of all of us, grew up in families where there was domestic violence and maybe never really dealt with that psychologically and healed it. And so they still think it's perfectly fine. And, I survived, why can't you? So there are a lot of problems that are psychological and internal that training, it's pretty tough for trainings to get at. But that said, there are these trainings. Fewer of them are mandatory, I would say, but there are some mandatory ones. But again, when they bring me in, sometimes the judges think I'm okay, but sometimes the judges don't like me because I'm a strong advocate for battered women and children, and they only want to hear from other judges. They only respect other judges, and other judges are less strong advocates because they're judges. And there you go. And I continue to refine my style, in part based on that kind of feedback, to try to find ways in that judges will accept. And I've found some ways in that are interesting, and I'm working with those a little bit in the evaluator training too. So it's tough training judges, though. It is not, again, it's not simply a matter of information. It is a matter of willingness to rethink how you see men and women and abuse and violence. And that is not just about information.
So we need to end soon. I'm going to ask you a very simple question to begin with.
I will try to give a simple answer.
Well, I think this one is I have two last little questions that shouldn't be too complicated. One, looking at criminal, looking at civil, and looking at family custody court cases. Do the victims have to be present in order for the court hearing to take place in the United States?
Most of the time, the answer is yes. There are some exceptions to that, where if the litigation has been going on a long time and the hearing doesn't require testimony from the victim, sometimes her lawyer or the prosecutor can get her excused, get a specific, get the judge to excuse her from showing up. But as a general rule, the answer is yes. Although I did say earlier, in the criminal cases, they have learned some ways to prosecute without the victim. And if they're willing to take the case forward without the victim, they can. They're free to do that legally.
Okay. And the last one, if somebody has been convicted once in a domestic violence dispute, and then they come back and they do it again, maybe with a different partner, maybe with the same partner, is the history of abuse admissible in court?
In most cases, yes. However, I wish this was simple. However, many custody judges will exclude it and will say that was already litigated. We're only talking about the new incident now. So let me put it this way. As a lawyer, I would always bring that forward, and I would always think it should be part of the case. Some judges will exclude it, and sometimes you can appeal that successfully, and sometimes you can't, but that takes a long time, and a lot of cases never get appealed. I've had appellate cases at DV Leap on that issue in the custody context.
All right, well, I'm going to wrap this up right now. First, Joan, thank you. Thank you so much. Again, for all of our colleagues who have joined this conversation, this is the first of what we hope to be many conversations. I think that Joan has done an excellent example of showing us where there has been progress on addressing domestic violence in the US legal system, but where there is still a lot of work to be done. And what we hope to be doing over the next bit of time is to have a forum where today we learned about a lot of things that concern the US system, where we can also share the Russian system. And because no matter where we are in our progress of addressing something that has been around for hundreds and thousands of years, we can always learn from each other, not because we can copy it, but simply because it's a slightly different way of looking at, unfortunately, a universal issue. So Joan, thank you so much for joining us. For everybody, next Monday, the 6th of December, we're going to be introducing the work and the women who run two very different shelters for domestic violence. And we hope that you'll be able to join us. It will not be on legal issues, because these are not people who are, I mean, they are aware of the law, but they are doing very other work. They are working with the victims on a day-to-day basis to try to help them claim back their lives. So that will be next Monday. Thank you guys so much.
Thank you.
And-
It was a real pleasure having this conversation.
Oh, amazing.
I look forward to learning more about what's happening in Russia with this.
Oh, good. All right. Thank you all. Take care.
Bye-bye.